USCIS is pretty much being consistently inconsistent and sort of took the clean extension for granted, increase so we can put it to the record, otherwise it would just create disaster down the road. And the clients really have difficulties in understanding the ramification of having those both tools and how to use them, especially when they travel. I always advise them, if you travel with an F1, you have to enter with your AP. But a lot of them they forget and will have to contact CBP, and it's actually has happened quite frequently in recent months. I've heard of an incident where the client followed my advice, showed the officer the AP document, and the officer said, "No, where's your F1 visa?" and still admitted her as F1, which is quite odd. But I think it's a must-do to catch the issue well in advance after it happened, and then contact CBP to correct the issue. Otherwise, it would just create disaster down the road. So I think now I've been asked multiple times about the EAD AP mandamus, and I'm like, so the combo card, the EAD AP has, up until maybe 6 months ago, we've been seeing them adjudicated, approved within 6 months, and now it's pushing 8 to 10 months, and a lot of clients are pretty much on the edge about it. And for those cases, I always advise, especially if you're waiting for six months or more, maybe just wait a little bit longer. They can get fast, and if you really have an urgency to travel, we can do the emergency AP or an expedite request if we have good evidence that the travel is really urgent. On the 526E side, a lot of clients, especially the rural investors, because they were told that they should be expecting maybe less than a year, around a year to a year and a half, and nowadays it's getting longer. And what we've seen at least is that you'll probably want to still wait a little longer. If it's a year and a half, maybe I would say probably wait at least 2 years and do more increase so we can put into the record when we file the mandamus, because it's certainly becoming harder and harder. So we probably don't want to abuse the system for the benefit of the industry. I would say, we all know 2026 is not going to be a smooth ride, but it really hasn't been for many years with the upcoming sunset of the grandfathering clause and the upcoming visa backlog for some of our clients. But I think this time will be different because for many years, I think between 2016 and 2019-20, we've had so many extensions and clean extensions and temporary laws, and then sort of people, I think, got complacent and sort of took the clean extension for granted. But this time I think will be different. We'll like Chris alluded to, right? We're coming together and we're making sure that clients' interests are protected in the going past the September deadline and the next year's extension. But on the other hand, I think we have to prepare for the worst, right? If you're a regional center, you have to prepare for the possibility that the client interest would probably dip if those things do materialize. And on the agent side, you have to look out for clients' interests and see if there's other alternative options. If EB-5 visa, let's say, gets super backlogged, and then clients having issues with the grandfathering clause expiring, and it will go back to the same cycle that we've all experienced after 2018-19, and there are just going to be other options out there, albeit inferior to EB-5, but those are things that we'll have to consider in the upcoming year.